starting with Mr. Hofmeyer's re-examination. Ms. Manda, you may remind Mr. Hofmeyer that he is still under oath.
Mr. Hofmeyer, you have been reminded that you are still under oath.
I understand. Thank you.
And I know that we must be mindful of questions of shortage of water, but should it apply only to the panel? We have glasses, but not water.
I'm tempted to say, don't make your problems ours.
I wish I could have somebody on whom I can, somebody who I can burden with my problems. And I'm sure mine are worse than yours. Thank you. Okay, good morning, everybody. Ms. Bawa, we are in your hands. Thank you for the water.
Mr. Hofmeyer, just a few minutes ago, you handed me a document. Can you just get that out of the way first before we start? I understood from you that it arises from what you had indicated to the panel you would revert in relation to.
Chair, it relates to the issue of how seriously the NPA was dealing with corruption matters over the last 8 years. I do have a lot of other documents, but I thought that this statement issued by Parliament probably summarizes the matter fairly accurately and without me needing to dig through lots and lots of old documents. So in June 2017, the NPA presented to Parliament the list of serious corruption matters that had been dealt with by the NPA. And the statement of Parliament in the second sentence said none of the cases were fully prosecuted through convictions, meaning all of them are outcomes where corrupt people have negotiated their way out of prison, which largely defeats the objective of using sentencing as a deterrent against corruption. There is a possibility that Scopa may meet with the political leadership of the ACT because the committee has a feeling that there's a lack of political leadership over the process to make its impact felt on the ground and in the eyes of the public. But as you can see, I think the concern by Parliament was essentially that in the presentation made to them about the outcomes of all the cases, that in no case there seems to have been a custodial sentence imposed.
And what do you want us to make of this document?
I think the point I tried to make the other day when I last gave evidence was that essentially in corruption matters the NPA had not pursued the serious corruption cases. You will remember that counsel for the other side handed in a list on Friday of some of the sentences that had been imposed. And I agree with the list, but that list essentially, if you look at the dates when those cases started, they all started in the early days of the anti-corruption task team in 1911 and 1912. So I agree that in the early days of the anti-corruption task team, some serious cases were done and prosecuted. But certainly after a period, that stopped. And I don't have the names of all the cases here, but clearly if you look at the issue that all the cases were settled for plea bargains, and it appears all of them for plea bargains without custodial sentences. Either these were not serious corruption cases, or people were being let off in serious corruption cases with very minimal punishment at all.
Have the parties been provided with copies of this
Yes.
document? Okay.
You also wanted to respond to a further aspect of the corruption cases in relation to the OECD matters you've indicated to me also arises from the cross-examination.
Chair, I do have a list of, you may recall that we are a member of the OECD Foreign Bribery Convention that we signed on. That process entails essentially that we are interrogated by the OECD regularly. We have to provide them with a list of cases we are working on involving foreign bribery. But the OECD also provides us with a list. So, for example, if India reports a case where South Africa bribed an Indian company, that will be added to the list of cases that South Africa should be dealing with. I'm not quite sure the extent to which Mr. McAdam had dealt with these issues, because at one stage he was the coordinator for foreign bribery corruptions. But I think, again, if you look through the list of cases that are on the OECD list, I've only got a list from October 2014. But again, I think here I don't have the details about the outcomes, because we've not had a process of similar to what Parliament had about the domestic cases. But again, on this list of, I've not counted how many, but there is about 20 pages of cases here. As far as my knowledge goes, not a single one of these cases are being prosecuted in court at the moment. Obviously, Ms. Jiba, Mr. Mrwebi may know something to the contrary, but at the moment, as far as my personal knowledge goes and my engagement with Mr. McAdam, which was prior to the start of this inquiry, but the reality is that these cases are not being dealt with.
Can I find out, Mr. Hofmeyr, are you going to be asking any questions about that evidence? Let me understand you. When did Mr. McAdam stop being responsible for this unit?
Chair, it's not that he's responsible for a unit.
Yeah.
But I think it was while Mr. Ngasana was the NDPP, he asked him to take responsibility for the foreign bribery cases, because South Africa was being very heavily criticized at the OECD about the lack of action on the OECD matters. As far as I'm aware, the OECD, as I said earlier, had actually now decided to come and have an inspection in South Africa, where they will look at every docket and what process there has been in each docket, which is one of their more extreme measures when they are concerned that the country is not fulfilling its obligations in terms of the convention.
But what has this got to do with Ms. Jiba and Mr. Mrwebi?
I think if you look at the history of these cases, many of them were on the agenda while Ms. Jiba was acting NDPP and while Mr. Mrwebi was the head of the SCCU. And if I remember correctly, the responsibility for dealing with these, for prosecuting these cases rested with the SCCU.
Where does it rest now?
As far as I'm aware, still with the SECU. So Mr. McAdam's role has been to report on the progress of these cases because of his institutional knowledge. I don't think for the last couple of years he has been going to the OECD meetings. I speak under some correction. But, you know, essentially at a time in the past he was made responsible by Mr. Ngasana to gather all the information about the OECD matters and to give us an overview of where we were with them, but also because we had to report on that to the OECD.
If I recall, I think evidence was already led, I think by McAdam, that he was removed from that and that the files were distributed among various prosecutors. So I think that's where McAdam left us in respect of the matters.
Yeah, that is correct, that he was removed, but he had gone at the time through this extensive exercise of gathering all the information about each case and where it was and compiling a report on that.
Was he finally removed? Because at some stage the matters were taken away from him, but then he had been reinstated to continue with the work that he was doing, particularly because he had to report on behalf of South Africa. And was there evidence that he had been finally removed? Finally removed, okay. All right.
I think, I mean, I'm not talking about the current situation there, but there was a stage where he was removed, and I think other people went to the OECD meeting rather than him.
Thank you.
Mr. Hofmeyer, would I be correct to state that if indeed there were no prosecutions in relation to these cases, then all the national directors were responsible, and that in the main, most of them had longer periods of engagement as NDP, as national directors, as opposed to Ms. Jiba? Would I be correct to say that?
I think to an extent. I think under Mr. Ngasana there was a there was a real effort to try and get on top of our obligations and to ensure that matters were dealt with, but he did not last very long.
You haven't answered my question.
I think if you look back at the list, there is indeed a number of arms deal cases on the list. That I think some of the previous NDPPs need to take some responsibility for. But it doesn't mean that when you become the NDPP, you're absolved from dealing with that responsibility, particularly because South Africa continues to report on all of those cases, and those reports goes to the NDPP, obviously, before they are submitted to the OECD.
I'm talking about duration. What do you say about duration? That some of them have been there for quite a while. For instance, if we were to say Mr. Sean Abrams was there, you can't then lay it at the foot of Ms. Jiba. When Mr. Simelane was there, you can't do that. When Mr. Mkche was there, you can't lay it at her feet.
No, I've agreed. I think that each of the NDPPs is obviously responsible for the time that they were in office. But when you do come into office, you also inherit all the cases from your predecessors. And I don't think it's a good point to say that because my predecessors did not do anything about it, I'm also not going to do anything about it. I think there's an obligation on the NDPP to ensure that these matters are dealt with. And, you know, it's not just a question of whether they are dealt with or not. The views of the OECD on our dealing with these cases, I think, does get impacted or does impact on our investment ratings and things like that internationally as well.
Thank you.
Can I also ask about the SCOPA document that you've just given to us? Would I be correct in saying that it would have been more helpful if we had statistics instead of a response that talks to the statistics and draws a conclusion from that? Because drawing the conclusion would be our job. It would have been much more effective or constructive if we had the statistics or the reasons that lay behind this document.
Chair, I indicated that I did my best to, and I have collected quite a lot of the material, but it is complicated. I've not had access to this for a number of years. The current NDPP has said that we must try and get that information. So I can offer that we can make it available to the inquiry, but it is going to take us several days at least to get the documents to verify the information in the documents. Whereas I thought why this is important is this is a place where the NPA is being held accountable. And I think the NPA had reported the serious corruption convictions to Parliament at the time. Parliament had then asked specifically for the sentences that were imposed in each matter. And I think the statement was the outcome of a parliamentary process where I think it was essentially that zero or very few people served any custodial sentence for serious corruption matters. I mean, the statement implies that it's zero, but there may have been a few. I was not privy to those submissions that were made. I'm trying to find the documentation at the moment.
And you will confine the documentation to what Advocate Mrwebi had suggested, just the context to that, statistical context to that conclusion that has been drawn, and it must be made available to all the parties.
Yeah. Chair, I'm just for clarity's sake, I mean, I'm happy just to give numbers, but I suspect people may want to verify the numbers against the names of cases.
That's part of the context.
Yeah.
Thank you.
But I think as soon as we can complete that process, we can make it available to the inquiry.
Thank you. Yes, Ms. Bawa?
It was suggested to you in cross-examination that there was a collective decision-making process. And I want to confirm with you whether, in your view, during the time that Advocate Jiba was acting NDPP, whether a collective decision-making process was in place in relation to decisions.
I think, just for clarity's sake, are we talking about a collective decision-making process in relation to high-profile cases, or more generally about the management of the NPA? Or?
Let's deal with it in three categories, because I think all of it in some way or another is relevant. Let's deal with it generally, in respect of operational and management issues, and in respect of high-profile cases.
I think the point I tried to make at the time was that the more collective leadership that was there under Advocate Jiba pertained largely to the overall running of the organization, the general issues that we were dealing with, that's reflected in some of the EXCO minutes and so on. But it did not pertain, as I think I said in my affidavit, to issues surrounding some of the more contentious cases that we are discussing here.
You were taken to the memorandum that Advocate Kennedy provided, my recollection was that Advocate Arendse read one or two paragraphs to you, and you had reflected, or you had responded to him by saying you were of the view that the document should be disclosed. Do you recall that?
I do.
I want to take you to paragraphs 47 and 48 of the Kennedy memorandum and ask you whether what is stated in those paragraphs is consistent with your recollection of the approach that had been adopted. Sorry, do you have it
Just
there?
trying to get
I'm
it.
assuming we've gotten our electronic glitches out of the way.
Are we talking about the memorandum saying statement submitted by Kennedy, or?
Yes, it would be in folder M, and it would be number 23 in folder M.
That's the one we have, yes.
Mr. Halfmeyer, I'm sorry, it's not 48, it's 47 and 37. I'm just looking at my note. 37 and 47. 37 was more in response to your admission to Advocate Arendse that the approach adopted was not that there was an objection to a disclosure.
Is it, sorry, 37 and 47? Sorry, if you can just repeat your question.
So I want to know whether, in particular, maybe with respect to 37 first, that effectively the position was that the NPA had not objected to a disclosure, and that is a reflection of the approach you said. You recall you were of the view that the document should be given, but that there had been a confidentiality in place, with the one side saying we're going to take you to court if you give it, and the other side saying we're going to take you to court if you don't give it. And so essentially between a rock and a hard place, pursuant to the advice which was eventually given as reflected in paragraph 47, you took the stance which you then took. And that was pursuant to the advice that Advocate Kennedy had rendered.
That's correct, yes.
Right. Now, also arising from under cross-examination came the issue as to what did you know about the Boyson matter. And in the course of that, you furnished to us a number of minutes of EXCO meetings. Correct?
That's correct.
Right. You and I had not previously consulted in respect of those EXCO minutes.
No, we have not.
In fact, to date, we have not consulted about those EXCO minutes.
Indeed.
Right. Now, what was the point that you were seeking to make in respect of the EXCO minutes? Maybe take us through them.
Sorry, Chair, I seem to have mislaid my set of minutes amongst all my papers here. I've got the final, sorry. I think the main thing that I tried to demonstrate in the earlier EXCO minutes is that the Booysens matter was one on which the NDPP had asked for reports, that it was discussed at the NPA EXCO as well, which is a sort of much bigger meeting, and that the need for him to get that report remains as an outstanding item on those EXCO minutes for several months. The particular set of EXCO minutes which I do want to highlight are those for 2 March 2015.
Sorry, it doesn't seem to be on the Dropbox, but I'm told they are in the judge's files or in your files. Let me just check where they are.
Reference?
To the other
Just
side.
give us a reference.
Maybe Advocate Mr. Hofmeyer, take us through it and tell us what the point was with reference to the dates of the documents. And I think that the research has gone to find the file.
Thank you. Not there.
So, Chair, the point is that this is minutes of a meeting at EXCO in March 2015, which is, as we know from the timelines, a considerable time after the initial decisions were taken. It says
Give me the date kindly of the meeting.
2 March 2015.
Sorry, we would also like to have those copies of minutes.
It was given to everybody when Mr. Hofmeyer handed it over to us.
I don't have them.
And
I don't have the minutes.
copies were made and provided, as I understand, from one of my juniors at the time. In fact, there was an issue about whether we had given the copies correctly back. So 7 or 8 sets of copies was made. Let me just see if we can sort it out. Mr. Hofmeyer,
I do have a one-pager, which is the only page I'm referring to.
let's not do that.
think,
Let me ask you another question while they sort this out, and we can come back to it.
There we are.
A junior confirms you were definitely given copies, but
I don't have them. I don't have a copy.
I'll go on to the next issue, and we can come back to that.
Okay. Have you also lost your copy, Mr. Rip?
No, I never had them because I wasn't here, but Advocate Ramaweli, my instructions are that he has them. So they were given to the team. I just don't have them with me. But it doesn't affect us.
Okay, I
weren't
think
in-
yeah.
We're not affected by the Booysen issue.
Yeah. But we'd just like you to keep you in the loop.
Thank you very much. Now, I realized yesterday that's a very important thing.
Very important. You never know. Okay. I think let's approach it the way Ms. Bawa suggests. Ne? Yeah, we'll come back to the matter.
Right.
Thank you.
There was a conversation about original decision-making powers of DPPs and NDPPs, right? And it seems to be, if I understood you correctly, Mr. Hoffman, I think it's important that this be clarified for the presiding officers, is that the decisions to prosecute essentially lie with the DPP with a very limited review intervention power to the NDPP. Am I correct?
I think that's essentially correct.
Right.
So the DPPs have the original powers to prosecute in their jurisdiction, and the NDPP's review power is not one where he can simply, or she, sorry, can just say the case must go away or must continue. It is a formal process. It's paper-based, and I think that's been what has been used successfully over the years to challenge some of the NDPP's decisions.
There is an exception to that, and that exception is in a select number of matters where you actually require the approval of an NDPP before you can take a further step. And one example is the racketeering, which is smack bang Boyson, and there are other examples, for example, the terror cases, correct?
That's correct.
And it's in those cases that a very specific power is then exercised by the NDPP. And it's that which I understood Advocate Arendse to be saying to you. Advocate Jiba had done 23 of those authorizations in respect of racketeering decisions when she was acting NDPP.
Yeah.
Correct?
That's correct. Yeah.
Right.
I mean, the law, if I remember, doesn't necessarily say that the NDPP makes the decision about racketeering, because that implies a whole lot of things, but that NDPP has to authorize the use of he or she must satisfy themselves that this is the appropriate kind of case to use racketeering provisions in, because they are wide and they could be used in cases that are not serious, and obviously you want to ensure that those powers are used in serious cases. But obviously the process also of necessity means that the NDPP, him or herself, must satisfy themselves that all the requirements to authorize a racketeering prosecution is in place. And I'm not sure if I should deal with it now or later, but that was essentially why there was a committee in the head office of the NPA that would scrutinize the applications in some detail, write a report to the NDPP on their findings. The prosecutors would, in many cases, still come up to head office for the engagement with the NDPP about the racketeering charges. So there was a fairly comprehensive process of interrogating, of toing and froing between the prosecution team and the head office team to ensure that racketeering is being used appropriately.
Now, at the time when the Boyson decisions were taken, which was roughly around August 2012, what was the team at head office that would deal with these matters? And what was the procedure in place?
Sorry, I'm just going to have to refresh my mind from my notes here.
Can we maybe place on record that I've not seen your notes and I've had no party in compiling your notes?
Indeed. And let me say that they are compiled partly from my personal knowledge of the process, but also from talking particularly to Mr. Mamabolo, who was part of the process for most of the time that we're talking about. So initially, the sort of the vetting process, if I might call it that, the scrutiny process, essentially rested with what was called the organized crime component in head office. It had various names over time, but it was people who who had to work with the provinces on organized crime matters. Initially, after the disbanding of the DSO in 29, it consisted of Johan Kruger and Mr. Mamabolo. At various times, a number of additional persons served on it. One of them was Anthea van der Bijl. There was Joni Spies, I believe, served on it. Terence Mlanga, sorry, I'm not sure I'm doing the name here correctly, and one other person. So there were 4 or 5 people who served on the desk at various times. They were also, each of them, allocated to a specific province, so they would take not sole responsibility, but their job would be to support the persons in that province on an ongoing basis, and if there was a bigger meeting or bigger discussion needed, they would obviously consult with their colleagues in head office. In relation to a racketeering application, essentially they would produce a file with the application and with a draft memorandum or authorization to be signed. It would be accompanied by a memo, the indictment, and in many cases, in most cases as I understand, the actual docket as well, so that they would have insight in the details of the criminal case. Then the team from the province or from the DPP who wanted to obtain the authorization, they would come to head office to make a presentation. Usually they would do a PowerPoint presentation of the details of the case, and there would be an extensive interrogation that often lasted more than one day. They would also check a lot of the details, make sure that nobody is misjoined in the case, have the details of what the enterprise is, how it is constituted, and in terms of the law, who we say were the managers of that enterprise. After that process, a final memo would then be submitted to the NDPP with the evidence and the docket. Or let me say, can't say that in all cases the docket, but in most cases the docket, or at least the crucial statements in the docket, would be submitted. There would be a discussion on some of the problem areas when it came to centralization, or even about where the head office team may have some problems that they foresee about the actual charges. A full bundle would then be prepared for the NDPP, and a date would be secured to meet with the NDPP. Usually it was about a 14-day period between the submission to the NDPP and the actual briefing with the NDPP. In the discussions with the NDPP, it would deal with, again, some of the same issues, particularly who would be the boss of the enterprise. If it was a national enterprise, who were the provincial bosses, and the sort of details of how one sees this criminal enterprise. In many cases, the NDPP, if the NDPP was happy with the presentation, would sign immediately while the team was still with the NDPP. And I think that was sort of done in a sense to make sure it's done while all the facts are fresh in the mind of the NDPP rather than waiting for a longer process. So in general, there was a sort of 10 to 14 day turnover, I think, was the target that the committee set itself for this process. So from my understanding is that before Mr. Ngasana came in, that it may have been only Mr. Mosing that was left, because Mr. Kruger had left and some of the other people may not have been active in the committee.
Can we just clarify, because Mr. Mosing wasn't on your initial list. You confirm that he was in that group at the time when the decisions were to be taken.
Yeah, I think he was not in the early group, yeah. But he did join the group at some stage. I don't have a date for that. From the notes that so once Mr. Kruger left, I think those who remained on the committee, as far as I understand, was Mr. Mamabolo and Mr. Dubada, and Mr. Mosing was brought in at some stage in that time to add to the team. So I think the rest of my notes maybe to some degree after the relevant period, but yeah. It says that Mr. Abrams later on signed the same racketeering authorization as Ms. Jiba had signed earlier. And at that time, there was a trip by Mr. Mahema and I think Dawood Adam to Greece to get Danikas to sign the affidavit that he had not signed previously, but he still refused to sign at that time.
But that was in the Mr. Abrams era.
That was later,
Now,
as I indicated.
it was put you in cross-examination that it was actually advocates Mosing and Noko who were the person that had made the recommendations on the racketeering charges. Do you have any comment in respect of that?
Yeah, I may have heard about Advocate Noko's involvement at the time, but I must say I did not have an independent recollection now. But it may well be the. I mean, if it said that she was part of the application, I wouldn't dispute that.
And it was also put to you in cross-examination that all of this was informed by a memorandum from Advocate Mosing. Do you recall that? That Advocate Arendse couldn't find at the time. And I simply want to place on the record that we have not been able to find a memorandum from Advocate Mosing to which Advocate Arendse referred. In fact, you were taken to an affidavit from Advocate Mosing, which was deposed to much later. You also became aware of, let me not go there, Advocate Mamabolo, and we will deal with this in argument, has put an affidavit before the inquiry without giving evidence, so that question is going to have to be dealt with in argument. But you had also attached to your affidavit a memorandum that had been provided to you by Advocate Mamabolo, which sets out his role in the Boyson matter, correct?
That's correct.
And in fact, he had no role in the Boyson matter,
Indeed.
based on the memorandum which you
Yeah.
provided.
And from my personal engagements with him at the time and later, it was clear that he had no role in that decision.
Now, if Advocate Chowki was involved in this process in relation to a racketeering charge which is emanating from KZN, who would have appointed him to be involved in that process?
I think that it can only be the NDPP that could make a request to somebody to do that.
Okay. Now, I'm going to step off this and we'll come back to the minutes because the minutes is another Boyson-related matter. You were then taken to...
Sorry, can I just ask on this topic? You say from your notes you're able to give us a list of these people that were part of the, what do you call it? Committee vetting component, not sure what. Was this a formal structure unit or was it ad hoc? Did EXCO know about it? How do we know that it was a formalized structure or whether it was an ad hoc structure?
Essentially, there was and my understanding, a formal structure called the organized crime component or something to that effect in head office that engaged with the provinces on a range of organized crime matters. And the reason
Can I interrupt you, and I'm sorry for doing that, because you say, according to my knowledge, it's something that you were not party to, you had no direct knowledge. It would be better if we could get somebody like Mama Bolo to come and explain to us. Would you agree that that would be a safer way of doing it?
You may have more details than I have, let me put it that way, but it was part of the structure of head office. The AFU that I was involved in also had a number of organized crime cases, so we were familiar with the process and what happened there, although we were not necessarily in the meetings, but the cases we dealt with had gone to the meetings and we were talking to the prosecutors who were involved in those cases.
So in answer to my question, you would say there was a formal structure, and I would imagine they'd hold meetings and they'd have minutes. This vetting committee. Or you wouldn't know?
From my sort of, as far as I know, people did take their notes in the meetings, whether they produced formal minutes. I doubt somehow that there was really formal minutes. There may have been a process to formally document decisions, but on the inner workings, I can't give you that level of detail.
And would there be, at any stage, with any of these cases where they come and serve in EXCO or at EXCO?
Normally, cases would only get raised at EXCO when there has been a big, either when they were very, very, very important, or else when there was a legal challenge or litigation or something that had gotten into the public domain. And then EXCO, somebody in EXCO may raise the matter and ask for it to be discussed.
You say it, you give the impression that it might have been a formal structure, but the question was it ad hocly created or was it a standing structure? Or was it created only for that Boyson matter, in other words? Was it ad hoc or was it a standing structure, which applied in all cases?
No, my understanding is that the organized crime component was a relatively long-standing structure, and as I said, the need for it was, because, as I said earlier, is that the DPP powers tend to be provincially based, or are provincially based. And organized crime would often happen in a number of different provinces. So the structure was both there to ensure that there was coordination between the provinces, so it had a semi-operational role. But one of the functions of the structure was to formally approve the use of the racketeering provisions. So but that was not its main function. It's sort of liaised with the provinces on an ongoing basis, informally very often, trying to ensure that there's proper coordination, all those sort of details.
Thank you.
Can I check, has everybody now got the minutes? Okay. I think the pack before you is chronological in the sequence that was given to us, Mr. Hofmeyer. And so the first document we had already dealt with, which was the meeting of the 25th of January, the St. George's meeting, where the debate related to the in-consultation was. We dealt with that earlier, or a few days ago, right? Your second one relates to the minutes of the EXCO meeting of the 5th of March 24, and if my notes is correct, it would be item 9A, which is material.
That's correct.
Right. You were present in this meeting, correct?
I was.
And we see that from the second page of the meeting that the DNDPPs and the EXCO there was together with the NDPP. Okay. And can you explain to us the context in which this arose?
I think it essentially arose out of the concerns that Mr. Ngasana had about the matter, and that he wanted to have it discussed at a formal EXCO meeting.
And he requested a report in this matter.
That's correct. When he started, he met with a number of prosecutors about different high-profile cases to be briefed, and in the context of this case, he had asked for a report to be presented to him.
And it's apparent from this minute that Advocate Jiba responded that Advocate Chowki would submit the report.
That's correct.
Right? And I just want to take you a little bit further because it goes something that I probably neglected to do yesterday. Under C on the next page, Advocate Jiba indicated that Advocate Chita was assisting with the finalization of the affidavit, and Advocate Mokgatla responded that LAD had no record of the matter and only appointed counsel to attend the matter together with Advocate Mozing. Does that accord with your recollection?
That's correct.
Right. And what was the upshot of the meeting in relation hereto?
I think the main conclusion, the main issue was still that Mr. Ngasana wanted to have a proper and formal report on what had happened in the matter. And that's reflected sort of on the action logs and so on afterwards.
And it remains on the action logs for several months, is that correct?
That's correct.
And you then provided us with your contemporaneous note at the back of the last document.
That's correct.
And can you tell us what that is?
So it is sort of cryptic notes in the nature of the notes I took. But I think the first one is just that we're waiting for a update on the status. The second note was that, which I think was an issue that I had disputed, but the team or somebody in the team had said that any prosecutor, or that the president, pres I think stands for president, says that any prosecutor can prosecute anywhere. I'm not going to go into the details of that, but I've dealt with those sort of issues in my main affidavit already. And it's true to some degree of people below a level of a deputy director of public prosecution. So state advocates, senior state advocates can be transferred from one jurisdiction or used in another jurisdiction relatively easily. But deputy directors of public prosecutions and directors, their jurisdiction is very specific to the jurisdiction in which they were appointed. So, having said that, for Mr. Chauke, for example, he has no jurisdiction to be in charge or give directions of a prosecution in another province. It is simply not allowed in terms of the law. It's the director of KZN who is in charge of that case. The only way that could have, that in some cases one can get around it is if a case happens, as organized crime cases tend to happen in a number of provinces, then the NDPP can make a formal decision to centralize that matter in one province or under one DPP so that one team is in charge of the case. But it's absent a centralization. I submit that it is simply unlawful for a DPP in one province to take charge of a case in another province.
And are you aware as to whether the Boyson matter...
Sorry, Ms. Bawa, can I just get clarity on something that is just said and which was raised by Mlotshwa in his evidence? I seem to recall that there was mention made of some delegations or authorizations which Mlotshwa might have signed in respect of some of those prosecutors. Is that possible within the nature of how the NPA works? If you say that when it comes to deputy directors and the directors that they're limited to their jurisdictions, but would such an delegation or authorization be possible and lawful in such circumstances?
I'm not sure I want to give expert advice on it, but an answer. But my understanding is that a prosecutor can be transferred to another jurisdiction. The necessary paperwork has to be done. But it's a relatively informal process that is within the ambit of what the NPA or the head of the NPA can ask for it to happen, and the directors can agree between themselves to transfer a prosecutor from another jurisdiction to their jurisdiction. Normally there would be a consultative process. You don't just put a prosecutor in somebody else's jurisdiction without the DPP agreeing to it. But yeah, the transfer for people below deputy director level is not tied to the issue of them being somebody who has original jurisdiction to prosecute, which both DPPs and their deputies have that original jurisdiction, and clearly that has to pertain to the jurisdiction where they were appointed.
Thank you.
So transfers cannot take place with regard to DPPs. You cannot transfer one DPP from a particular jurisdiction to another DPP's jurisdiction and authorize that DPP to act or to serve in that jurisdiction. It can only be done with officials below DPPs. Because, as you say, DPPs have original jurisdiction.
Just to qualify what you're saying slightly, so DPPs are presidential appointments. So in any event, the president would have to appoint them to another jurisdiction, and then they would have absolute power in that jurisdiction, so the other DPP has to get out of the way. The president has to get somebody out of the way. So that's not really happened, that the DPPs themselves are transferred. I think what happened in this case is that the deputy DPPs are used in another province. But the difficulty with them is, as with the DPP, they actually have original powers to prosecute in the province where they are appointed. Obviously subject to the supervision and whatever of the DPP in the province, but they can, if the DPP is on leave, he can appoint one of them in his place, and they have his or her place, sorry, and they have full powers in that province. But they are appointed to a specific jurisdiction. If somebody marries a woman in Cape Town and would love to move down to Cape Town, it can be done. But I think in the case of the deputy DPPs, it's the minister who appoints them. So the minister has to appoint them formally now to be a DPP, a deputy DPP in Cape Town. So they lose the powers that they had in Joburg. They now have a new appointment in Cape Town, and they can exercise those powers in Cape Town. But what you can't do is to send them into some random province and to prosecute a case there in the jurisdiction of another DPP when they themselves have jurisdiction in a different province and it hasn't been changed.
Can you maybe just move on the note that we were discussing? There are a couple of headings there which are quite cryptic, and could you maybe elaborate on that for the inquiry?
I think I've dealt with the first two. I think the third note is just a reference that there is a civil claim. I think that was reported in the meeting relating to the Boysons matter. And then my next note is around the issue about whether there was evidence in the, and what were the shortcomings, why did we have these findings from the court. And I then record that Mr. Mtenjwa said that they are going away to get evidence against Boysons. They still have not received the affidavit from the Greek and from Mhlongo. Mr. Ramahite, SR, asked the team, said that the team had been asked to brief EXCO and that have not responded. I assume that means previous to this meeting. And it said that in an earlier meeting the team conceded that there is nothing. When we talk about nothing, I assume nothing in terms of evidence. And then the last note is just that NDPP will call the team to another meeting.
So let me shift gears now. In your cross-examination, I want to take you to the issue of Advocate Jiba's affidavit, the one which was deposed to in the context of your 2015 affidavit, in respect of which you were cross-examined on the context of that statement. And the actual statement is to be found in folder 1.3 at page 9. Sorry, I think it's folder G, 1.3, page 9. Or 7, sorry, 7. 7. So it's folder G. Folder number 1, and this is 1.3, page 7.
Sorry, we're just battling to get that document still.
Sorry, I'm just trying to make sure we are in folder G, item number 1, and then 1.3.
1.3, page 7.
Okay, 1.3 is something called statement of case.
Case.
Page number?
7. Put it into context, this was the statement of case in the Labour Court in the matter where Advocate Jiba had issued an application against the NDPP, but I'm taking you to the actual affidavit which Advocate Arendse has cross-examined you on at length in respect of the evidence as to what Advocate Jiba had actually deposed to at the time. Now, you correctly conceded in cross-examination.
Chair, sorry, just we're starting at the we're starting at the beginning.
For staff, you don't need to read it because you'd already gone through it and you were given an opportunity to read it in cross-examination. This is the affidavit in which Advocate Arendse had put the submission to you that there is absolutely no mention of Mr. Nell and there's no indication of Mr. Nell being implicated in the affidavit at all, and that it's a relatively benign affidavit in the context of providing information pursuant to a request from police. That was, as I understood, the proposition that was put to you in cross-examination. Do you recall that, Mr. Hofmeyer?
I do.
Right. Now, this affidavit was put before the Labour Court in the context of a challenge to the disciplinary proceedings that was brought against Advocate Jiba, correct?
Correct.
And there were a number of grounds upon which those disciplinary proceedings were brought, and one of those grounds was effectively a contravention of Section 41(6)(a) of the NPA Act.
Correct.
Right, which effectively said no person shall, without the permission of the National Director or a person authorized in writing by the National Director, disclose to any other person any information which comes to his or her knowledge in the performance of his or her functions in terms of the NPA Act or any other law.
That's correct.
Right. But for the sake of completeness, there were also other charges that were brought, and if you go down in the document to page 11, one would see.
Sorry, can you maybe just refer me to a paragraph rather?
I want you to go to page 11 on the iPad, which is effectively the charges that I understand, or that were being brought against her at the time.
My pages are sort of numbered 32 and so on. Oh, sorry, is that?
No, it can't be. Not in 1.3. Oh, sorry, you're talking about the numbered pages on the right-hand side. Sorry. I'm taking you to number 34 on the right-hand side. I was looking at the electronic numbering. My apologies.
Sorry, I've got it.
Right, so those were the alleged acts of misconduct that were brought against her at the time as a consequence of her actions, or alleged actions, right?
Correct.
Now, I want to take you, while you keep that open on that page, I want to go to the hard copy of your affidavit so that we can contextualize where this came from. Right. You will see in your affidavit, and I'm in your 2015 affidavit. Okay. At WH 142. Are you there, Mr. Hofmeyer?
Yes.
Right. These are the annexures to the affidavit which you filed in the matter to that, and this is the affidavit which Advocate Jiba filed in the Labour Court, which you annexed.
That's correct. Yeah.
Right. Now, if one goes to page 147 of Advocate Jiba's affidavit.
Sorry, WH 147 or?
Sorry, in the Dropbox, where is it?
In the Dropbox, it would be under number the Dropbox, you can find it under M. You go to the folder 14. I had indicated you that we had shifted all Advocate Hofmeyer's affidavits and annexures to one place for you to see, and you will see at 14.2 the list of annexures. So we would be dealing with 14.2 and 14.3 in the context of the context. And one sees the explanation which Advocate Jiba provides for her involvement in the matter at paragraphs 2.2, where she says she was approached by Prince Mokgoro to assist the police with regard to a certain investigation involving one of the senior members of the NPA. She didn't know who the person was that was being investigated, and she was later approached by members of SABC introduced them to her as Commissioner Mluli. Do you understand that to be Richard Mluli?
I do. I think he was the only Commissioner Mluli at the time.
Sorry to do this. 14.2 is not what you're reading on the Dropbox.
14.2, sorry, Advocate Masuku. Look at 14.5, which is the annexures, right? And then to make it easy for you, you scroll down to WH 147, which would be the electronic page. With the electronic page 69, but it would be the marked by WH 147. You with me? And at that juncture, he was the Deputy Commissioner of Police, correct?
You're talking about Mluli.
Yes, because you actually have attached to your affidavit an affidavit from him in which he identifies himself at that juncture as the we have the affidavit attached to this which identifies him as the Deputy Commissioner of Police.
I would just say a Deputy Commissioner,
A
because I
deputy.
think there were a number.
Yeah, my apologies. Right. And together with a Senior Superintendent Mabula and a Captain Mano, they approach her and they tell her that they are investigating Gerinel and effectively require her assistance in that investigation.
Correct.
The explanation given is that they took her statement, which is NJ1, which is the same as the document which we have open on the screen, just at a different location because you didn't annex it, all right? And they asked her to explain certain aspects of the scorpions to them, which one sees from her affidavit. All right. In paragraph, and if we just stop at that juncture and go back to the Dropbox, and if you go to 1.2 in the Dropbox, and there is a question coming, I just need to contextualize the question. If one goes to 1.2 in the Dropbox on page 35, of the electronic copy.
Nazreen, Ms. Bawa, sorry. I think you must first indicate the folder. I see we have,
Sorry, it's folder G. It's the court records.
Sorry, if you can just be under G, where do we find it?
1.2. And it would be the page marked 46 in the corner, right-hand corner, and you see it's the supporting affidavit of Richard Mluli. And you are correct, he identifies himself as a Deputy Provincial Commissioner for the Gauteng province at the time, right? And this was the affidavit which he deposed to in support of Advocate Jiba's Labour Court application. You aware of that?
I am.
And if you go down in his affidavit, he provides his version of what Advocate Jiba explains in her affidavit, that under 2.1, that he had received information from a Captain Mano pertaining to alleged criminal conduct, and he authorized an investigation and delegated it out because of Advocate Nell's seniority. He was overseeing the investigation to finality. And he then sets out in paragraph 2.3 that the information that they had was that Advocate Nell had lied under oath in order to influence the outcome of a criminal case favorable to one Cornwall Shavunga. Do you know who Cornwall Shavunga was?
Yes, I knew him quite well. He was one of those rising stars in the Scorpions at DSO at the time.
Right. And he actually worked under Advocate Nell at the time. He reported to Advocate Nell. Is that correct?
That's correct, yeah.
And then you see at paragraph 3.1, they say they kicked off the investigations by contacting Prince Mokgoro, who was attached to the integrity unit at the NPA, and we know from Advocate Jiba's affidavit that she got involved pursuant to a request from Advocate Mokgoro to assist the Commissioner Mrwebi with his investigation, correct?
That's correct.
Right. And we see in paragraph 3.4, he then meets with her and he requests that she treats all information that is provided to her with absolute confidence. And she agreed and understood to do that. One sees that in paragraph 3.5.
Correct.
And in 3.6, that they contacted on various occasions to clarify what they required to advance our investigations and obtained a statement. And we know that that statement was only obtained on the 18th of October 2007, because that's the date of the statement that we have. Right?
Correct.
Now, if we go back to Advocate Jiba's affidavit, which should be open in your hard copy at WH 147 in paragraph 2.5. She then tells us that some weeks or so later, they again approached her and informed her that there were issues that they need to discuss with the senior state prosecutor pertaining to the investigation. They said that they didn't know the local senior prosecutor as they worked in other areas, and she informed them that she would inquire as to who the senior state prosecutor was, arranged to meet them at the magistrate's court, and did so. She then asked for a senior prosecutor and was shown to the office, but they were busy. Whilst they were waiting, Mr. Mveka appeared and asked if he could assist, and she knew him because they had gone to school together, but didn't actually know that he was a senior prosecutor. And she informed him that there were some senior police officers who wanted to discuss a case with the senior prosecutor. He said they can come and see him, and indeed the investigating officers went to see, and she left. Do you see that in paragraph 2.5 and 2.6 on WH 148?
I do.
Right. Now, if you page on in your documents and you go to page 176, you will see what is a report provided by Advocate, or I'm not sure if he's a senior he's a senior prosecutor, Mr. Mveka, and he confirms that he had met Advocate Jiba in the corridors waiting outside Mr. Licharaba's office. Do you know who Mr. Licharaba was at the time?
At the time, I did not really, I'd heard the name, but I can't say I knew who he was or where he was working.
If you turn just one page earlier, you see that he had also provided the statement and he identifies himself as the senior prosecutor. On your
That's
affidavit.
correct.
That's correct. Right? And he then says that they indicated that they wanted to bring an application for a warrant of arrest, but they didn't possess a docket. And he told them to go and get the docket and to come back, and that the investigating officers then came back the following day with requesting an arrest warrant. He then realized that the warrant was for a senior official in DSO Viz Gerinel, and he referred them to the DPP. And the DPP at that time was?
It was Mr. Mzanyati.
Mzanyati. Right? And he entered his reasons in the docket diary that he was not in a position to apply for a warrant and the matter must be brought to the attention of the DPP.
Perhaps I should just add that we do have prosecution policy guidelines that require the authorization of the National Director of Prosecutions before any member of the NPA or police are charged. So I think that's what he was alluding to, is that he cannot just authorize it.
I stand corrected that I haven't looked at the ones which would apply in 2007, but I seem to think it allowed the Director of Public Prosecutions to do so.
Sorry, that you may be correct. So that would have been Mr. Mzanyati. But it would have to be, yeah.
He then indicates that they left his office and he met him in the corridor talking to Advocate Jiba. I told her that the protocol has to be followed and the DPP must be approached. Now, one sees attached to your affidavit, and can I take you to page 179, WH 179, which is page 422. This is a report which is dated 2 November 2007 to Advocate Mshay, who was then the NDPP, correct?
He was the acting NDPP,
Acting
yes.
NDPP. And we see on WH 184 that this comes from Advocate Mzanyati.
That's correct.
Right? And he identifies himself then as an acting Deputy National Director of Public Prosecutions, but which could have been the case at the time he wrote the memo. Correct?
Correct.
And he details a number of aspects in this report, including what was contained in the docket for the prosecution of Gerinel. And what I couldn't find, which I think has come up repeatedly, including what Advocate Arends had put you in paragraph 8, I couldn't find the magistrate's transcript, but the closest I come to it is Advocate Mzanyati records that the regional magistrate in the Shavungu matter, Mr. Lamprecht, was quite scathing of Advocate Nell's behavior during the course of the investigation, in respect of which Mr. Shavungu was prosecuted. Most of the criticism centered on his apparent failure to observe that Mr. Shavungu was up to no good. And then he gives you two extracts of the magistrate's conclusion which negatively reflect on Mr. Nell, Advocate Nell. Do you see that?
I do.
Now, I think you testified to this on the cross-examination that ultimately the case against Mr. Shavungu was lost before the magistrate and reversed on appeal. Is that correct?
I think so.
Okay, we'll leave that for now. All right? But in essence, Mr. Hofmeyer, I want to make a different point, so maybe answer it differently. Let's assume for purposes of argument that if the case of Mr. Shavongo was reversed on appeal, and I'm probably saying the name very atrociously right now, then effectively any criticism which was leveled against his boss for not observing what was then alleged to be criminal conduct would also fall away. Would that be the case?
It's Chavunga. But yes, that would be the case.
Because effectively there would then be no criminal conduct imputed to Mr. Help me out here.
Chavunga.
Shavongo, right?
That's correct.
And that could probably be the explanation why nothing further after the matter was withdrawn against Advocate Nel then ensued. Would you agree?
That's correct. And, you know, normally when one does get a judgment that's being appealed, you would wait for the outcome of that appeal before you take serious decisions about it.
But that's a different point. Right. Now, it was put to you by Mr. Ramaweli last week that a magistrate had, well, let me first finish Advocate Mzanyati's memorandum before I jump. So we can see that there were statements in the docket. There was certainly a comment made by the regional magistrate. Advocate Mzanyati details what I take you through on the encounter to get the warrant of arrest. And then in paragraph 12, he then further says that there was also an overture made to Advocate Mozing, who was then a deputy DPP, to also provide a warrant. Do you see that in paragraph 12?
I do.
Right, and for the sake of completeness, and I'm not going to take you completely to that, but just because we were dealing with the context, the statement from Advocate Mozing is at 171 of your bundle. Where he details that a request is made to him for a warrant and that there isn't sufficient evidence at the time, and that he effectively reports the matter to Advocate Mzanyati.
That's correct.
Right. He then also indicates, and which Advocate Mzanyati details in paragraph 12.2, is that he is informed that the allegations against Advocate Nel were brought to their attention by certain sources within DSO. You see that on page WH 183 at 12.2.
That's correct.
He was then asked, and it's apparent from his statement, but Advocate Mzanyati was clearly liaised with him, indicated that they were carrying out instructions from higher up, and he was being asked to listen to two DSO officers who at that stage arrived at the DPP's office and were waiting outside Mozing's office. He refused to talk to these officers, as he took the view they should have reported the allegations to the NPA authorities first. Mozing saw Advocate Jiba and another gentleman outside his office. Do you see that?
I do.
He then relates a conversation that he then receives from Advocate Mayema, that he was also approached to issue a warrant of arrest.
Correct.
And that's the same Advocate Mayema that is involved in the Boyson matter, correct?
Yes, several of the role players have stayed involved in controversial cases over the years.
Now, the proposition that was put to you by Advocate Ramaweli was that a warrant of arrest was granted by a magistrate, which presumably found that there was a prima facie case, and you can't be said to be questioning such a warrant of arrest. And if you had any difficulties with it, the proper course that you must take is to go and have it reviewed and set aside. Do you recall that?
I do.
Right. I presume that applies both in the analysis of the Nel scenario and the Mluli scenario. Would apply equally the principle.
That's correct.
Right.
Ms. Bawa, you might want to let us know how long you will take so that we can decide on the lunch break, how long to have the lunch break.
I'd like to finish this because I'm in the middle of a chronology
Yeah,
on the context. Can
I
you
can see
bear
that.
with me a
That
few
is why I want
minutes?
to know how long you're
Yeah,
going to
not
take.
long on this.
So that we can complete that and have a shorter or
Yeah.
a later lunch and maybe even shorter. Thanks.
Right. Now, if one looks, if we go back on your annexures, you will see at page 156, there's a legal opinion which is rendered by Advocate McAdam, dated 6 February 2009. Do you see that?
That's correct.
And he's been asked to consider whether there are reasonable prospects of success in charging any person in connection with the arrest of Advocate Nel. You see that's his instruction?
Correct.
And he's requested to identify any outstanding investigations. And his memo is pretty comprehensive, but I simply want to take you to the issue of the warrant. And for that, I want to take you to paragraph 2. Now let me start on paragraph 2.9 on page WH157 of your bangers. Right at the bottom he says, the Chief Magistrate Pretoria is approached by unidentified members requesting a warrant of arrest and search warrant for Mr. Nel. He referred them to the Senior Magistrate Raffaello, and then on the next day, and you'll see the date, on the 22nd of November, a warrant of arrest is issued and a search warrant, correct?
Correct.
You testified that that warrant of arrest was executed when Nel came back from leave in January of the following year, correct?
That's correct.
Right, so that was some 7 or 8 weeks later.
Correct.
One sees that detailed in paragraph 2.12 that he's arrested on the 8th of January at 2100 hours on his way home. In paragraph 2.13, one sees that Advocate McAdam records that undated reports of what appears to be a summary of the docket against Advocate Nel by Mr. Lufondo and containing an opinion that there is no prima facie evidence on the listed offences. The report, however, contains a conclusion to the effect that the decision taken and the reasons therefore were discussed with the investigation team and the commissioner, and there was an understanding on the way forward. Do you see that?
I do.
And he was one of the senior magistrates which prosecutors we've identified. Now, in paragraphs 3.1 to 3.4, 3.1 to 3.8, Advocate McAdam details what are the salient contents of the docket which existed in respect of, and the evidence available in respect of Advocate Nel. Do you see that?
I do.
And you see in 3.4 there's a reference to Advocate Mrwebi.
I do.
And one of the questions which was asked by Advocate Ramaweli the other day was whether, I stand corrected, and I was related to the involvement of Advocate Mrwebi, and your answer was the Browsmill report.
Yeah.
I didn't understand that question.
I think I omitted something in my answer there. So, just if you need clarity, there was the issue about the production of the Browsmill report, where Mr. Mrwebi had made a statement on the DSO management meeting and what had been discussed there. But I was, when I went through my documentation over the weekend, I was reminded that there was an investigative report on Mr. Mrwebi and his involvement in this matter as well.
Interrupt. I was trying to understand the question that you say Mr. Ramaweli asked.
So Mr. Ramaweli had asked Advocate Hofmeyer, Mr. Hofmeyer, what was the issues in relation to Advocate Mrwebi that connected him to these matters at the time. And as I understood Mr. Hofmeyer's response, he connected him via the Browsmill report to the Celebi prosecution at the time. He didn't connect him in any way to the events in relation to the docket of Advocate Nel. And my next question was to say to him, it does appear from para 3.4 that also in the docket of Advocate Nel was a statement from Advocate Mrwebi, then head of the KZN DSO. Do you recall that, Mr. Hofmeyer?
I do.
And in fact, what he does in what's recorded there is he sets out the DSO investigation procedures, and according to this, he expresses an opinion that Nel's version was outrageous and hard to believe, if I'm quoting from the opinion.
That's correct.
So would it be correct to say that there were two events in respect of Advocate Mrwebi that arose? One related to the Browsmill report, and two was the statement he had made in respect of the Nel arrest?
That's correct. But perhaps if I can just add on to what I had said before, I also have come across a report that was done at the time that was an analysis of Mr. Mrwebi's telephone records, and particularly his calls to Ms. Jiba and I think to Mr. Mluli, which I think is relevant to the fact that it does appear that he had either met with people from crime intelligence, but at least were in regular communication around this issue with them and Ms. Jiba.
Now, Mr. Hofmeyer, that information is not before this inquiry. It's not contained as an annex to your affidavit, and it's not been provided to us at all. You agree with that?
I do. I'm asking, in a sense, for leave to hand it in, if it's not too late.
We would be loath to allow you to introduce new evidence every time when you respond to a question. Try to confine yourself to answering the questions that Ms. Bawa puts to you, unless it is absolutely necessary. And if it becomes necessary, then we need to have it deposed probably on affidavit and let the other parties also into this thing.
My apologies, Chair.
Now, if one looks at paragraph 5.9 of Advocate McAdams' opinion in the first line, he says, after the arrest of Advocate Nell, he was granted bail, withdrew the charges, the magistrate withdrew the charges. He was of the view that there was no evidence against him on any of the charges. Did I ever have an unspecified agreement with the SABC as to the way forward? As far as you are aware, those charges were never reinstated, correct?
Not just as far as I'm aware. They
Not-
were never, well, Mr. Nell's never gone on trial for it. They may have been reinstated at some stage, but I don't think it became public.
And in 5.10.1, Advocate McAdams sets out the reasons why the allegations, in fact, he concludes in the opinion that there was some basis to investigate Advocate Nell based on the evidence in the docket. But he says that in 5.10.1, that the allegations related should have been reported to senior management. Do you agree with that?
I definitely agree with that.
And then in paragraph 6.2.1, which is why I'm coming full circle back to the context of Advocate Jiba's affidavit then made on the 18th of October, and which provides workings of the DSA. And he concludes in paragraph 6.2.1 that based on the information, he draws the conclusion that she was the source of the police investigation into Advocate Nell. Do you see that?
I do.
And he says, read with the affidavit of a friend and colleague, which is the affidavit we traversed the last time you gave evidence. I think it's a Mr. Nemaramo, which places her at the location at the times when there were attempts to procure the warrant of arrest.
That's correct.
Right. So would it be fair to say that if you're looking at the context, in the context of the arrest of Gerrie Nel, it's not only the contents of the affidavit, but also the context in which the affidavit was given?
That's correct.
And in fact, if we go back to Advocate Jiba's affidavit at 1.2, where I taken you earlier, she in fact confirms in paragraph 11 of that affidavit might be the wrong affidavit, it's not 1.2, it's the one. But her confirmation, without taking you there, is that she had assisted the police in the investigations against him and had given a statement. I might be at the wrong box. Sorry, let me just get the correct reference for that conclusion. I just need to find a reference, Madam Chair, and maybe this is a good time to take the adjournment because I'm done with that section, dealing with context.
We still need to know how long you're going to be.
I think about half an hour.
After lunch then?
Yeah.
Okay. Is that okay? It will work for all of us. Thank you. We adjourn until 2 o'clock. Thank you for your patience.